Well, thank you for your patience. So, welcome everybody to the last day of World Arbitration Update. I have the incredible privilege to be here today with this roster of experts on international investment arbitration as well as humanitarian law. My name is Maria Lucia Carlos. I'm Senior Associate of Strategy, a boutique law firm with presence in Bogota and Washington, D.C. I'm also part of the executive team behind the World Arbitration Update. So for me, it's a real honor to have all our virtual participants as well as our in-person participants. So welcome to the last day of this event. This event, of course, as you may know, was co-founded by Jose Antonio Rivas as well as Ian Lehr. Jose Antonio will join us in a bit. He's stuck in a plane. He was traveling from Washington, D.C., so he will join us in a bit. So for you to know, World Arbitration Update has two main objectives. One is to update on issues on public international law, investment arbitration, dispute resolution, as well as commercial arbitration. And the reason why this is one of the main objectives is because in today's world, it would be almost impossible to get to read all the awards issued by international arbitration tribunals, as well as decisions issued by different international courts. So what we will try to do with this incredible organization is try to update the international community on the matters that have been happening in the last years. As to the second objective of the World Arbitration Update, is the decentralization of dispute resolution and investment arbitration, because we are under the notion that the international arbitration does not only happen in the main centers of the world, being Paris, London, New York, but it also happens in unusual places as Colombia, as different places in Africa and India. So what we would like to do is to give a platform to different individuals and experts on this field who may come from different jurisdictions, such as Colombia, different countries in Latin America. So this year, we are very glad to announce that we partner with the National Autonomous University in Mexico. We started the World Arbitration Update last week on Thursday and Friday, and we had incredible participation and events based in Mexico City. So today's session is going to be investment arbitration in war and armed conflicts. Can investment legal principles coexist with international humanitarian law? So before we start, I would like to yield the floor to Walter Alévalo, which is the president of Academia Colombiana de Derecho Internacional, which is our partner for this particular event. So welcome, Walter, and you have the floor.
Thank you very much, Maria Lucia, and thank you everyone for being here, either online or in presence. For us, the Academia Colombiana de Derecho Internacional, which is happily very well represented in the people that is with us in the session, by you, by founding members, by professors who take part of the academy, also by former GESUP competitors, by GESUP trainees and trainers. It is a real honor to contribute in the, as to the diffusion and the perfection of international law. We strongly believe that nowadays investment arbitrations is one of the most relevant branches of international law in Colombia. I teach international law. I teach public international law in Universidad del Rosario, and every time I finish a course, I try to explain my students how they can get involved in international law. And sometimes it is hard to tell them to develop a career as an international judge. It's hard to tell them to develop a career in human rights. It takes time. But I'll also tell them that just a couple of blocks from here in La 72, there's plenty of law firms that all of them are really well into deep in investment arbitration. I think not only for Colombia, but also for Latin America, investment arbitration has become a new way, a gate to enter into international law discussions. And it's also a very interesting way to enter into the issues of public international law. The topic of the session of today is precisely one of those fields in which public international law correlates with this, which was considered before a difficult field of international, but now it is a broader a well-known and very relevant field. So welcome to you all. Thank you for being here. Also, thank you to the firms and to the World Arbitration Update, to the Agency of Defense of the State, which is also present here. And I hope you enjoy the roundtable.
Thank you, Walter. Well, I will have the privilege to moderate this session. It was supposed to be moderated by Jose Antonio Rivas, which is one of the co-founders of the event. As I mentioned before, he's stuck in a plane, but he will be for the end of the session. So I'm very honored to assume this role in his replacement. So our panel, which touch upon on the relationship between international humanitarian law and investment arbitration. And of course, it will try to answer how foreign investment is protected under the investment treaty regime during times of armed conflict. There is little doubt that, of course, violent and political volatile circumstances can affect foreign investments, and that if a state has failed to exercise sufficient care in protecting foreign nationals, it could be held responsible for the injuries incurred by them, even if those losses were caused by non-state actors. So, to address these issues that must be resolved, and that luckily is not my place to do it because it's a very hot topic and a very difficult issue to answer, I'm joined by a group of leaders on this field that I will now proceed to introduce. So as first panelists, we have Marta Lucía Zamora Ávila. She's a lawyer from Universidad Externado de Colombia with studies on criminal law, which is essential for this topic. She's former Attorney General and Deputy Attorney General of Colombia, former Assistant Justice of the Supreme Court of Justice and the Constitutional Court of Colombia. She was the agent before the Inter-American Court of Human Rights, representing Colombia on 4 opportunities. And currently, she's director of the National Agency for the Legal Defense of the State. So welcome, Marta. Next, we have Amanda Lee, that join us online. She's an arbitrator and consultant at Costigan King in London. Her practice focuses on commercial dispute resolution with particular emphasis on the finance and waste management industries. Amanda is a visiting lecturer at the University of Law, UK, and holds various advisory roles. Next, we have Carlos Arevalo Narváez. He's professor of international law and international humanitarian law at Universidad de La Sabana in Colombia. Former assistant justice, magistrado auxiliar for those in Colombia, of the Colombian Constitutional Court. In 4 opportunities, he has been requested to act as an expert witness before the Inter-American Court of Human Rights, and has also acted before this court as agent representing the state of Chile. Currently, he's the Dean of the School of Law and Political Science at Universidad de La Sabana. Welcome, Carlos. Next, and we also have him online, we have Eduardo Zuleta. He's an independent arbitrator who has served as chair, co-arbitrator, and sole arbitrator in commercial disputes under the rules of the major institutions, and a proceeding arbitrator and co-arbitrator in state investor disputes, including annulment committees under the ICSID Convention, involving states and investors from Latin America, Europe, Asia, and the Middle East. Next, we have Dr. Yuri Sirlik. My apologies, Yuri, if I'm not pronouncing your name correctly. He's a senior lecturer at City Law School, University of London. He was previously lecturer and senior lecturer at the University of Liverpool. And prior to that, he was research fellow in international arbitration at Whitmer University of London. He has taught international investment law, international arbitration, public international law, and international dispute settlement. His PhD thesis was basis for a monograph that calls the protection of foreign investment in times of armed conflict. So I think that we have a real expert on both systems here. And lastly, but not least, we have Santiago Zuleta. Santiago is the head of the business and human rights practice at Zuleta Beyond Borders. His practice focuses on conflict resolution, human rights litigation and consulting, investment arbitration, and transitional justice. He has advised companies, official entities, and civil society actors in the implementation of legal and communication strategies to ensure compliance with national and international standards on business and human rights. He also has a lot of experience on dispute resolution and investor-state disputes, and he's a candidate for a master's degree in international human rights law at the University of Oxford. So welcome, Santiago, and welcome to all our panelists. Well, before we begin with our session, I would like to encourage our virtual assistants to please enter any questions you may have through the chat. We'll be happy to read them through the session. So now, for a starting point for this incredible session, I would like to yield the floor to Marta Lucia, who will provide us a presentation in Spanish, and later we will provide a translation of this presentation for our online participants about the application of human rights and international law in Colombia and how these obligations in these two areas of law can impact other areas of law such as economic law. So Marta, adelante.
Muchísimas gracias. ¿Sí? Ya, ahora sí creo que... ¿Sí me escuchan bien? Sí. Bueno, muy buenos días para todos y todas. Muchísimas gracias por esta invitación. Un saludo muy especial al doctor José Antonio Rivas, quien está llegando en este momento, al doctor Carlos Arévalo, lo mismo al doctor Walter Arévalo, y veo que están conectados el doctor Zuleta Ríos y Eduardo Zuleta, así como otras personas que fueron mencionadas y que en este momento nos acompañan virtualmente para llevar a cabo este panel tan importante sobre el tema de derecho internacional, derechos humanos y lo relacionado con los tribunales de inversión. Yo debo decirlo, como directora de la Agencia Nacional de Defensa Jurídica del Estado, mi agradecimiento inmenso. Soy una aprendiz permanente de este tema, del cual me he enamorado desde que estoy en el cargo de directora. Pues los tribunales de inversión no han sido mi desarrollo profesional, como vieron en la presentación tan generosa que ha hecho la doctora María Lucía. Mi vida ha girado alrededor del derecho constitucional y el derecho penal, y hoy en día pues es un privilegio como directora acercarme a este tema tan rico académicamente, tan importante, y como les digo, del cual me he enamorado, pero reconozco mis falencias. No soy una experta en el tema, pero sí hago todo lo posible por aprender cada día sobre una temática tan importante para Colombia como lo es para todos los países que nos rodean. Es un tema mundial, digámoslo así. Después de esta pequeña introducción en la cual reconozco el agradecimiento a ustedes por permitirme estar aquí en este importante foro, debo iniciar refiriéndome a la Constitución Política Nuestra. Es fundamental, pues de allí tomamos no solamente el artículo 2 de la Constitución, que establece esos fines esenciales del Estado, de lograr la satisfacción de los derechos y lograr precisamente darle esa oportunidad a todas las personas que conforman el país, el poder satisfacer y tener esas posibilidades de satisfacción de esas expectativas en torno a su desarrollo, a su personalidad, lo que va incluido en derechos muy personalísimos y también a los derechos sociales, económicos, culturales, a los cuales se ha ido desarrollando la jurisprudencia alrededor de esas necesidades de satisfacción de todo ciudadano. También debo referirme como digamos, un punto fundamental en el inicio de cualquier tema que toquemos alrededor de los derechos humanos, es el artículo 93 de la Constitución Política, el cual se refiere a la importancia que tiene a partir de la vigencia de la Constitución del 91 los tratados, instrumentos internacionales vigentes en Colombia y que forman parte de ese concierto de normatividad nuestra interna y que son complementarios de todos los derechos fundamentales y de todos los derechos que se contemplan en la propia norma superior. Para mí siempre ha sido un artículo de un cambio real en la Constitución del 91. Yo estuve en la constituyente, fui secretaria de la Comisión de Justicia, y este artículo constituía como si abriéramos una ventana al mundo para que todos esos tratados que en muchos casos ya eran leyes de la República, realmente tuvieran una presencia en la jurisprudencia, en la interpretación de las normas, y por eso este artículo 93 constituye como ese cambio normativo en Colombia para poder integrar la normatividad internacional. Esto nos permite entonces vernos como también se ha suscrito, y Colombia lo tiene suscrito, nada menos que a la Convención Americana sobre Derechos Humanos. Formamos parte de ese sistema interamericano, es decir, tenemos una vinculación absolutamente directa, real y muy importante para el país con la Convención Americana, lo que significa que nosotros somos parte de ella y respetuosos de todos los derechos que allí se contemplan y se consagran, y especialmente de su forma de protección a través del sistema interamericano. Entonces, eso nos indica a nosotros que ese anclaje que tenemos en el artículo 93 y en el artículo 2 de la Constitución nos hace generar, como lo vamos a ver, una interpretación normativa muy sui generis y muy especial, en donde vamos a tener puestos nuestros ojos tanto en ese concierto internacional como en este artículo 2 de la Constitución Política, como el deber del Estado de satisfacción de los derechos. En la actualidad, Colombia cuenta con 18 acuerdos vigentes y 8 acuerdos suscritos pendientes de entrar en vigor. Es importante tener en cuenta cómo hemos ido en un avance muy vertiginoso, lo diría yo, en la necesidad de generar esos vínculos con otros países para efectos ya del desarrollo del país, digamos, de este avance que se ha tenido en los vínculos con otros países para lograr el mejoramiento y el desarrollo del país, como todo lo que significa la inversión extranjera, el poder lograr cada vez mejor la satisfacción de los intereses de un Estado y sus connacionales. También, como le decía, hacemos parte de la Convención Americana de Derechos Humanos y comparecemos ante los órganos de protección a estos derechos que se encuadran en el sistema interamericano. Por eso, desde la Agencia Nacional de Defensa Jurídica del Estado, tenemos una dirección internacional que no solamente representa al Estado en los tribunales de inversión, ya sea bajo las reglas de UNCITRAL y también el CIADI, sino también tenemos esa defensa del Estado y esa representación del Estado en el sistema interamericano, ante la Comisión Interamericana y ante la Corte Interamericana de Derechos Humanos. Por eso yo lo digo digamos, con una gran satisfacción, cómo hemos logrado en este tiempo generar una cultura de defensa del Estado, no a ultranza, lo diríamos como defender al Estado, porque eso significa recursos que se ahorran, sino defender al Estado, y en aquellos casos en los cuales vemos que son situaciones de manera temprana, hay que, digamos, reconocer el daño causado a las víctimas, especialmente en los casos de conflicto armado que vamos a tocar ahora. Hay digamos, una predisposición y un ejercicio que estamos haciendo con gran, digamos, con un conocimiento y una voluntad inmensa de no generarle al Estado hasta la espera de una sentencia condenatoria de la Corte Interamericana, sino aquellos casos que han resultado para el país y que hoy en día todos lo conocemos como causantes de un daño en el cual hay una participación de agentes del Estado, llevar precisamente al logro de la reparación de la víctima, a permitir que la víctima pueda tener una temprana reparación, y esto también es un logro para el Estado, ese reconocimiento del daño causado. Por ejemplo, tenemos la reciente sentencia de la Corte Interamericana, pero miren ustedes ya a nivel de corte y de condena al Estado en el caso de la UP, un caso emblemático de 30 años en el sistema interamericano, en donde pues no solamente es todos los delitos que allí se analizaron y se tuvieron en cuenta, contemplados como violaciones a los derechos humanos e infracciones al derecho internacional humanitario, en desconocimiento y exterminio, llamémoslo así, aunque es una palabra tan fuerte, a un partido político, pero esto hubiera podido llegarse a un reconocimiento del Estado digamos, a nivel de la Comisión Interamericana, y el Estado colombiano haber reconocido de manera temprana es un decir porque fueron 30 años en el sistema interamericano, pero en muchos casos los estamos en este momento trabajando, digámoslo, en el mejor sentido, un diálogo permanente con las víctimas. Hemos llegado, la semana pasada tuvimos un evento en la Universidad Externa de Colombia, en donde suscribimos acuerdos de solución amistosa, hicimos talleres con servidores públicos, porque esta es una muy buena opción dentro de la forma de lograr una solución amigable, respetuosa y dignificante para las víctimas en los casos en donde la defensa es absolutamente imposible para el Estado. Entonces, tenemos estos campos de acción tan importantes en donde llevamos esa representación del Estado, pero hoy en día tenemos una gran conciencia que no es una cuantificación en cifras, sino en satisfacción a las víctimas y en reconocimiento que somos un Estado que ha fallado en muchos temas y que hoy en día estamos ante la oportunidad de poderlo reconocer de esa forma. Entonces, tenemos de un lado, pues, estas bases que yo voy a ir sentando, ese principio del artículo 2, también en todos los artículos y en muchos de ellos vamos a encontrar ese respeto por los derechos humanos, ese anclaje en el artículo 93 de la Constitución Política, y ahí empiezan a surgir estos derechos económicos, pero también los derechos económicos, sociales, culturales, y hoy en día fundamental los temas relacionados con la protección del medio ambiente, con la protección de la naturaleza, de los seres vivos, temas que cada día cobran mayor importancia y en los cuales Colombia ha tenido un protagonismo importantísimo, no solamente por, digamos, la presencia del presidente de la República directamente en esta temática, sino porque ya es hoy en día un sentir de la humanidad de llegar a un cambio y a un reconocimiento de la importancia que tiene hoy en día el respeto por el medio ambiente y por la naturaleza. Entonces, Colombia ha impulsado la implementación de estrategias que garanticen el cumplimiento de nuestras obligaciones internacionales en materia económica, pero también relacionada con derechos humanos. Y pues lo vemos en el actual plan de desarrollo que fue sancionado la semana anterior, Plan de Desarrollo 2022-2026, Colombia Potencia Mundial de la Vida, en donde encontramos referencias especiales a las inversiones sostenibles, ya con esa terminología, inversiones sostenibles que le dan, ya empieza a generarse, digamos, una línea de pensamiento que va a quedar plasmada en los acuerdos internacionales relacionada con buscar ese equilibrio tan importante entre el desarrollo económico, pero también el respeto por los derechos humanos, por las temáticas que hoy en día son fundamentales, como son el respeto por las comunidades indígenas, por sus usos y costumbres, por lograr esa simbiosis sin que esta signifique pérdida de derechos de unos y otros, pero lograr ese equilibrio que es hoy en día uno de los secretos más importantes para el desarrollo de la humanidad. Entonces, esta política busca sentar las bases para que el país logre cerrar esas brechas tan grandes en materia económica y social a través de esa transformación productiva que tenga ese eje fundamental en protección del medio ambiente, en protección de los derechos humanos, la paz en los territorios, y también ahí incluyo, como les decía a ustedes, toda la temática de respeto por nuestra ancestralidad, que está también contemplada en la Constitución Política, por nuestra historia, que no es otra que hoy en día las 18 comunidades indígenas vigentes en Colombia, reconocidas, y en las cuales desde la propia Constitución está ese respeto y esa dignificación. Entonces, nuestro país, pues esta visión que hago de manera muy rápida constitucional, debemos tenerla presente al momento de la suscripción del tratado, de la interpretación de sus cláusulas y de especialmente que ese conocimiento se tenga por parte de los árbitros ya en los casos concretos de los tribunales de inversión, porque son situaciones y particularidades muy de cada país, y aquí hablo del nuestro, que deben ser conocidas con gran, o sea, en su historia, porque a esto le sumamos una de las situaciones de mayor dificultad que se tiene para el desarrollo de esta inversión, de la inversión extranjera, que como les digo, está ya contemplada en el plan de desarrollo y es una realidad frente al conflicto armado y a estas situaciones tan complejas que vive nuestro país. De un lado, con un acuerdo de paz que viene desde el 2016, que no ha logrado su implementación total, pero otros grupos disidentes, la posibilidad de un nuevo acuerdo de paz o por lo menos unas intereses inmensos de lograr ese interés de todos los colombianos de lograr esa paz, con otros acuerdos, con otros grupos al margen de la ley, pero a su vez momentos tan difíciles de violencia, de situaciones de orden público, que no necesito hacer mención una a una, porque no es más que abrir el periódico, escuchar las noticias y todos los días tenemos dolores y situaciones tan graves que no solamente impactan en el vivir diario de los colombianos, sino especialmente en lo que significa el desarrollo como país en la inversión extranjera. Entonces, nos pone en un plano, miren ustedes, una realidad constitucional, una normatividad muy clara frente a todo esto, una realidad y vivencia de un país, que todo esto debemos buscar ese equilibrio y ese análisis razonable para encontrar ese punto, digamos, de poder lograr esa interpretación de cláusulas al momento de no solamente la suscripción del contrato, al momento incluso de lograr aterrizarlo a una ley o en el momento en que la Corte Constitucional lo analice y, por supuesto, en el momento en que se presente una controversia de inversión, en el momento de hacer esa interpretación tan importante. Por esa razón, al momento de suscribir los acuerdos de inversión, Colombia ha sido consciente de la necesidad de crear remedios y mecanismos que protejan legal y materialmente las inversiones de los efectos que traen los conflictos armados. Me refiero a la inclusión de cláusulas de compensación sobre las pérdidas que pudieran llegarse a presentar como producto del conflicto armado. Entonces, esas cláusulas las encontramos hoy en día en acuerdos internacionales de inversión suscritos entre Colombia, Brasil, Turquía, Francia, Venezuela, que es uno muy reciente, y Estados Unidos, entre otros, en los cuales se ha contemplado esa posibilidad de tener esa cláusula de compensación ante situaciones como las de conflicto armado. Pero entonces se empieza uno a preguntarse, ¿cómo describir una cláusula en un tratado que contenga las varias y las situaciones particulares tan complejas que se viven en Colombia? ¿Sí? Y ahí, pues ahí viene situaciones como conocer esa historia, saber qué sucede en esa región en particular, que el inversionista no solamente sea plasmarlo en una cláusula, sino que tenga la posibilidad de relacionarse directamente y aún conociendo lo que puede llegar a suceder, asuma ese riesgo como puede asumirse en materia penal frente a aquellas conductas delictivas que pueden causarle un daño a una persona. Lógicamente no estoy haciendo una equiparación exacta, pero es un poco porque el derecho penal ha tenido que ceder frente a el consentimiento de la propia víctima, siempre y cuando se respete, por ejemplo, la lex artis, que es fundamental. Si una persona va a una clínica para que le hagan una lipoescultura, sabe que el riesgo es alto, ¿sí? Pero si tiene la información, el conocimiento informado de cómo es esa práctica y se toman las medidas preventivas necesarias, pues los resultados de una mala práctica jamás podrán ser atribuibles a la víctima. Pero digamos que hay un nivel de conocimiento del riesgo. Lo mismo podría hacerse un análisis, guardadas proporciones, como les digo, en los inversionistas frente al conocimiento que se tiene de situaciones particulares. Hoy en día Colombia tiene tribunales de inversión a los cuales no me voy a referir de manera muy concreta porque están en este momento en curso, pero en zonas difíciles, sobre todo hoy en día de minería ilegal, ¿sí? En donde ya no están esas cláusulas, pero hay una realidad que debe ser interpretada por los árbitros para conocer exactamente qué ocurre en esa región, cuál ha sido históricamente esas controversias o esas situaciones conflictivas laborales, y más hoy en día sobre el tema de minería y sobre el tema de la situación que se ha ido mezclando entre la ilegalidad de la explotación minera en zonas del país no en condiciones adecuadas. Es decir, a esto se mezclan muchos temas sociales que son muy graves al momento de hacer una valoración sobre incumplimiento, sobre, digamos, un trato justo y equitativo, sobre un equilibrio que se puede llegar a romper o a generar situaciones de dificultad que debe analizar un tribunal. Entonces, estas cláusulas consagran la obligación del Estado de observar el tratamiento nacional y la nación más favorecida en relación con las medidas de restitución y compensación que se tomen frente a las inversiones que ha sufrido pérdidas a causa, por ejemplo, de la guerra, y así encontramos cláusulas de compensación que se disponen previamente para efectos de prever cualquier situación que se llegue a presentar. Esas cláusulas de compensación por pérdidas son obligaciones que deben quedar, digamos, plasmadas de manera real, y ahí es donde yo me hago esa pregunta, ¿cómo al detalle, ¿no? Esto tiene que ser de manera muy general, como ocurre siempre con las cláusulas que se establecen en una normatividad, que no pueden abarcar todas las situaciones porque son difíciles, como son aquellas que surgen de manera social, como que pueden incluso surgir muchas veces por causas que no fueron previstas, diferentes, ¿sí? No es fácil generar esa serie, digamos, esa claridad frente a las cláusulas, pero es una invitación que se hace, digamos, desde la academia para pensarlas, para analizarlas con mucho cuidado, para ver cuál debe ser su verdadero contenido, para que estas generen la seguridad al inversionista, la tranquilidad al inversionista, pero igualmente al Estado le den ese margen de juego de poder prever otras situaciones que pudieran llegarse a presentar a futuro. Lo vimos hace muy poco, lamentablemente, en la toma del caso de Emerald en San Vicente de Tahuán, si no estoy mal, unas situaciones que llegaron hasta la pérdida de la vida de unas personas, secuestro, pues se habla de toma de rehenes, de todo esto, que afectó profundamente, incluso con una situación muy grave a nivel pues ya de Estado, una situación de resolverla de manera inmediata, cómo hacer, llevar a la fuerza pública, generar todo lo que sucedió allí. Miren ustedes, yo creo que difícilmente podría describirse, y hay que tener en cuenta factores territoriales, políticos, sociales, que ha ocurrido en esa región para que pueda hacerse un análisis real sobre lo que ha ocurrido. No más, lo pongo de ejemplo, a raíz del conflicto entre Rusia y Ucrania, pues Rusia ha enfrentado 10 nuevas controversias de inversión con Ucrania como nacionalidad de los demandantes, la nacionalidad de los demandantes. Esto ha producido una gran cantidad de reflexiones que nos ponen sobre la mesa a ver una situación que no se preveía y que jamás había podido ser analizada pues, con esa seriedad de que eso iba a ocurrir en tal momento. Entonces, pues lo pongo sobre la mesa, se debe revisar cuáles son los efectos socioeconómicos de la guerra, entre los cuales identifico principalmente 3. Uno, se afecta tanto a la inversión extranjera como a la inversión nacional. Colapsan las instituciones gubernamentales, dando lugar al incumplimiento generalizado de los compromisos que previamente se hayan hecho. Los gobiernos, sus fuerzas armadas, los grupos al margen de la ley y las mafias menos organizadas pueden tomar a los inversores como objetivo militar, que es el caso que mencionábamos, para controlar las infraestructuras construidas y explotadas por dichos inversores. Son situaciones límite, ¿no? Bien complejas que ponen al Estado mismo, a la sociedad y a una población determinada en una situación de altísimo riesgo y preocupación, pero también tenemos de otro lado que es una población que recibe las regalías, que está teniendo un mejor nivel de vida, que está logrando que toda la población trabaje allí, que ha logrado un mejoramiento en esa calidad de vida. Entonces son factores que deben sopesarse con gran cuidado y equilibrio para poder encontrar una probable solución la más adecuada. Las consecuencias directas de estos efectos para el arbitraje de inversión empiezan en primer lugar por el incumplimiento o ese presunto incumplimiento de la obligación de protección y seguridad plena. ¿Sí? Es decir, ahí son palabras cuya interpretación es también de una altísima complejidad poder establecer esa obligación de protección y seguridad plena. De pronto, en zonas en donde históricamente, como les digo, se conoce la dificultad social que existe, pero pueden surgir otro tipo de situaciones detonantes que generen otras causas que no están contempladas dentro de esa obligación de protección y seguridad plena. Sí, es de una gran dificultad poder generar esa seguridad frente a la manera como debe quedar establecida esas cláusulas. Entonces, pues hay una claridad, el inversionista se ve afectado por las consecuencias de los conflictos armados y lógicamente él siempre alegará que el Estado violó la cláusula de garantizar esa seguridad. De igual forma, el Estado también pondrá sobre la mesa argumentos relacionados con situaciones imposibles de prever y que se salen, digamos, de las posibilidades que habían sido objeto de valoración inicial. Este tema pues también nos lleva a pensar en la suspensión de los tratados internacionales durante los conflictos armados, situaciones de suspensión que pueden estar desde el acuerdo, digamos, de la posibilidad amistosa de llegar a una suspensión, hasta situaciones que pueden llegar a generar una eventual demanda contra el Estado, en la cual nosotros como agencia procuramos que dentro de esa línea que tenemos, que es la prevención del daño antijurídico, esa terminación se haga en los mejores términos para evitar una demanda al Estado y, lógicamente, una pérdida de recursos. Esto está al orden del día. Dentro de unas políticas nacionales como mundiales está la descarbonización, la búsqueda de energías limpias, pero ya el Estado venía en un desarrollo a través de inversionistas extranjeros de exploración y explotación, como está pasando con el tema del fracking, ¿sí? En donde hay que empezar a generar normas de transición, que esa también es una solución importantísima, normas de transición que nos permitan lograr, digamos, una salida digna, una salida respetuosa de los inversionistas, una salida la mejor para el país, y por eso ahí vuelvo a ese equilibrio y a esa razonabilidad que hay que lograr. En el proyecto de ley antifracking, en el cual participó la agencia precisamente para esas acciones preventivas, generamos, y en eso pues ya fue aprobado por el Senado, ahora va a ser tránsito en la Cámara de Representantes, en el proyecto de ley, de una normatividad que consultamos y trabajamos muchísimo desde la agencia, que son las normas transitorias para digamos, para lograr ese tránsito hacia el no fracking, para la exploración de yacimientos no convencionales, a través de normas que sean razonables, equilibradas, y que sean, digamos, las que buscan la mejor solución. Siempre alguien va a perder o perder un poquito, pero lo que se trata es que sean respetuosas de los inversionistas extranjeros, como también de esas políticas que el Estado ha implementado o ha hecho públicas frente a la descarbonización y la búsqueda de energías limpias. Entonces, ahí vemos que hemos hecho un trabajo de búsqueda de esa transición para que estos sean procesos que no generen el día de mañana un daño al Estado. Por eso, esas dos preguntas. ¿Hasta qué punto son efectivas las protecciones de los tratados de inversiones en tiempos de conflicto armado? ¿Y hasta qué punto son apropiadas dichas protecciones como marco para garantizar los derechos de los inversionistas en tiempos de guerra? También, porque veo que ya se me está acabando el tiempo, es importante hablar de esa protección reforzada de inversionistas que Colombia ha tenido también dentro de esta línea de respeto por la inversión extranjera, y por esa razón creo que somos un país respetuoso a pesar de las situaciones que vivimos, pero sí podemos considerar que en esta materia siempre está en la búsqueda de lograr ese equilibrio frente a la inversión extranjera. Esa sería más o menos la apuesta que desde la agencia queríamos contarles a ustedes, cómo estamos absolutamente comprometidos con la búsqueda de la menor afectación y que sea esta una parte del progreso para el país, en el sentido que esto significa el mejoramiento de la calidad de vida de las personas. Gracias a todos por su presencia, tanto quienes me acompañaron virtualmente, y aquí quedo para si hay alguna pregunta que sea necesario absolver. Muchísimas gracias.
Thank you, Marta Lucia. I think this presentation has been very insightful, and I think that actually gives a lot of perspective on understanding the interaction between different international systems. That I think that it's something that people that actually works in a specialized regimes like WTO investment arbitration sometimes tend to forget. And that is actually grasping a lot of attention in international investment disputes. And nowadays, there has been like a new introduction of new generation of international investment agreement that actually contain the state's right to regulate and obligations of investors to protect the environment and to respect human rights, which of course I think it is key to take into account in the defense of a state and in the future investment agreements that any state might like to enter in. So with this, we would like to move to the presentation of our presenter today. There is Dr. Jurij Zillig. As I mentioned before, Jurij will bring to this session the best of both worlds because he's an expert on both investment arbitration and international humanitarian law. He will provide us an intervention about the effects of our conflict on treaties and if investment treaties continue to apply in armed conflict. So welcome, Jurij, to this presentation.
Hello, everyone. Can you hear me?
Yes. Yes, we can hear.
Perfect. Thank you very much, Maria Lucia, for introduction and for inviting me. First, I would like to congratulate you on organizing World Arbitration Update. I think that decentralizing arbitration is such an important and commendable goal, and I'm honored to be part of this. And it goes without saying, I'm also delighted to participate in this esteemed panel on the topic that is very dear to me, as you've mentioned. But to clarify, there is nothing dear about war. I think we can all agree that it brings nothing but destruction, devastation, and death. And I think it was John Steinbeck who said that all war is a symptom of man's failure as a thinking animal. And I fear that as humankind, we haven't done enough thinking as we keep failing again and again. Discussing legal protection of foreign investment in wartime may seem irrelevant or even uncouth, given that there are much more important humanitarian considerations at stake. And yet, there is a long history of conflicts affecting foreign investors. The first arbitration cases concerning foreign investors actually stemmed from revolutions and other violent events of the 19th and early 20th century, many of them taking place in Latin America. And the rules and standards of investor protection were clarified by those first arbitration tribunals and mixed claims commissions, still apply today as part of customary international law, informing the interpretation of investment treaty standards. However, in terms of modern investment treaty arbitration, up until relatively recently, there has not been much case law. When I started researching this topic as a PhD student around 10 years ago, I had to focus my analysis mainly on one case, significantly, the first investment treaty arbitration, APL versus Sri Lanka. Many of you will be familiar with the case. It concerned the destruction of investor facility at the hands of Sri Lanka military. But soon thereafter, this changed as the conflicts in North Africa, Libya, Syria, Crimea, Egypt gave rise to a significant number of new claims for losses that foreign investors sustained in those violent situations. Some of them are still pending, others already resulted in arbitration awards. Russia's invasion of Ukraine is likely to lead to further investment arbitration claims. So where does this leave us? The topic of investment protection and war can be observed from three perspectives. First, and most interesting for arbitration practitioners, is the perspective of investor as a victim of violence. This perspective concerns the standards of protection in investment treaties, full protection and security, armed conflict clauses that Martha Lucia has mentioned, how effective these treaty provisions are in armed conflict. Do they apply in the same way as they do in peacetime? The second question, most interesting to policymakers, but also academics, I think, is a question of fairness and appropriateness of applying investment law in times of armed conflict, when the state's control over its matters is seriously constrained. And investment treaties could restrict a state's sovereign right to react to certain military and other security threats, or even complicate the post-conflict transition to peace. Now, the question is whether other international legal frameworks, which were specifically designed to regulate the conduct of war, notably international humanitarian law, are more appropriate for such situations. And there is a third perspective, one that has mostly preoccupied human rights lawyers. And it centers on the investor not as a victim, but as someone who contributes to violence or who is complicit in human rights violations and war crimes taking place in conflict-affected zones, for example, through their private security providers. The question here is, what are these obligations and responsibilities that investors have during armed conflict? How to enforce them? So my co-panelists will address, I think, most of these themes. But since the goal of this conference is to give an update on legal instruments and case law, I wanted to talk about a topic that is perhaps a bit obscure, but has seen some development over the past years, namely the so-called doctrine on the effects of armed conflicts on treaties. This doctrine concerns the question that every arbitration tribunal faced with a war-related claim has to answer first, which is, do investment treaties continue to operate in armed conflict at all, or are they terminated or suspended in whole or in part? And you may think, well, yes, of course, they continue to apply. That's why we have so many cases from recent and ongoing conflicts. And you would be correct in a way. In most cases, investment treaties will continue to apply in wartime, but not necessarily always. Historically, most treaties between belligerent parties were abrogated with the outbreak of war. And this classical position under international law started to change in the 19th century. And since then, several schools of thought emerged addressing this question. Throughout the 20th century, the topic attracted a lot of attention of public international law scholars, diplomats, and municipal courts, especially American English courts, and eventually also the attention of the International Law Commission, whose extensive research and consultation on this topic resulted in the ILC draft articles on the effects of armed conflicts on treaties, which were adopted in 2011. Now, there is still political will for the articles to become a binding convention. However, they do present a useful guide on this subject, and in some parts they can be taken as a reflection of customary international law. So why am I mentioning these articles? Because for the first time in history, they have been expressly applied and interpreted by an international adjudicative body, which happened to be an arbitration tribunal. In 2020 case, Güris versus Syria. In this case, the investor, a Turkish construction company, claimed that the actions of the Kurdish armed groups which damaged its facilities were attributable to Syria, thus breaching Turkey-Syria bilateral investment treaty. Syria, on the other hand, argued that the treaty was suspended due to civil war, which was internationalized because of Turkey's involvement in it, and therefore no treaty claims could be made. Syria said, tribunal does not have jurisdiction because the treaty is suspended. Tribunal was not persuaded. Ultimately, it rejected Syria's arguments, and in doing so, in my view, made some errors in understanding of the ILC draft articles. And I discussed that in my recently published article, and I don't have time to discuss all of the flaws in tribunal's reasoning, but I would just like to highlight two issues. First, the tribunal held that under customary international law, Syria had an obligation to notify Turkey in writing of its intention to suspend the treaty. Since it didn't do that, the investment treaty could not be suspended. That is not a correct position. There is no notification requirement under customary international law. The ILC draft articles provide a guide for states to send notice to inform the other state of suspension, but that is instructive and not mandatory. And second, the tribunal also considered factors that may indicate whether a treaty is susceptible to suspension. But in doing so, it was quite selective. It cherry-picked some, but completely ignored other factors expressly listed in the ILC draft articles. So, for example, it ignored the number of parties to a treaty. Historically, bilateral treaties were more likely suspended than multilateral treaties. But perhaps even more importantly, it also ignored factors pertaining to the characteristic of armed conflict, such as territorial extent, scale, intensity, degree of outside involvement. All of these factors combined would suggest a greater possibility of Turkey-Syria BIT being affected by conflict in some way. Perhaps upon further analysis, the tribunal could find that some of the treaty provisions, for example, on the transfer of funds from Syria to Turkey, were incompatible with Syria's policy in wartime. So in conclusion, despite the criticism that I'm raising, the Güris decision has several important implications. Investors may find reassurance that the treaty rights continue to apply during armed conflicts, protecting their investments. Host states, on the other hand, may be inspired by Syria's defense and start invoking the effects of armed conflict doctrine in their pleadings with a more polished argument, but also in their diplomatic statements, and thus contribute to the evolution of state practice and clarification of customary international law, which is quite in a blurred state. And lastly, the decision may also reignite scholarly interest in this subject, which used to be one of the most popular topics of international law. So on this note, I will conclude. Thank you for your attention.
Thank you, Jerry. I think your intervention is actually very pertinent because something that as international investment lawyers that we tend to forget sometimes is that investment arbitration is actually part of international law, and that part of international law is general treaty law, and treaty law is much more than Article 31 of the Vienna Convention of the Law of the Treaty. So thank you so much for those insightful comments. Now we are moving to Carlos, and we are very lucky to have Carlos here because he's an expert in international humanitarian law, so he can give us a different perspective, different from investment arbitration. So in particular, in my case, I'm very looking forward to learn from your intervention. So let me turn to what I would like you to ask to you, and is in which manner should investment arbitration and international humanitarian law coexist? Can they actually coexist, or should we give more weight to international humanitarian law over investment arbitration when both systems collide? So Carlos, you have the floor.
Thank you. We talk to this microphone or in
It's-
general? It's fine. Perfect. Well, Maria Lucia, thank you very much. And it's a true pleasure to be here in, I will say, a dual hybrid panel, because then we have people remote, people that are here, and we also are trying to conciliate two different branches of international law, which is investment law and international humanitarian law. And I believe your question and the question that you asked me to answer is quite pertinent. I'll say IHL is a branch of international law located in a cluster of what one may call the international protection of human person regimes, where it coexists with other branches such as international human rights law, international criminal law, transitional justice, and yes, investment law, among many others, all with the common international, transnational intention or objective to protect persons. IHL, neither IHL nor investment law is isolated, fully independent regime, but rather is a special regime, as may be concluded from the 2006 ILC final report on fragmentation of international law, that has a common trunk in general international law, as was highlighted at the moment by George Abisab. There cannot be a totally state-contained regime within legal order. By legal order, we understand the general international law. If the special regime, says Abisab, is to remain part of the international legal order, some relationship, however tenuous, must subsist between the two, which is precisely what you were referring to when saying this is still international law. Otherwise, if all links are severed, the special regime becomes a legal order unto itself, a kind of legal Frankenstein or Kelsen's gang of robbers, and no longer partakes in the same basis of legitimacy and formal standards of pertinence. IHL, as a special regime of international law, rather than a self-contained regime, must be articulated under the principle of harmonization with other branches of international law, such as investment law, having common vehicles of navigations, such as international responsibility or sources of international law, which was what you were referring, to help guarantee a common general international ground. I will defend in this brief presentation that IHL and investment law principles not only may, but must coexist in the context of investment in states such as Colombia, where there are ongoing armed conflicts. I don't know if you realize, but Colombia is a country that have at least 7 non-international armed conflicts ongoing. by recognizing as an example due diligence under full protection and security as a modified objective standard. I know that this is controversial for investment lawyers. I'm sorry, probably I'm too basic for international humanitarian lawyers and too basic for investment lawyers, but that's the intention that I have to try to conciliate both topics. And its application in context of civil unrest or even conflict, I will conclude that IHL should serve as a normative guideline that will allow arbitrators to understand the level of responsibility of states or investors in scenarios where, in relation to conflict, physical threats or injuries have been suffered by the investor and his or her property. My presentation will be divided in two parts. I will give some basic elements about IHL and its principles, and then I will address the issue of the use of IHL standards in the full protection and security claims. Now, turning to the first point, the basics on IHL. Hersch Lauterbach wrote in 1952, if international law is in some ways at the vanishing point of law, the law of war is perhaps even more conspicuously at the vanishing point of international law. International humanitarian law, also known as the law of war, the law of armed conflicts, or jus in bello, is the branch of international law specifically applicable in context of armed conflict. Its primary objective is to limit the consequences of armed conflict by restricting the means and methods of warfare that parties to a conflict may employ, and to ensure the protection and humane treatment of persons who are not or no longer taking a direct part in the hostilities. It is based on a balance between considerations, very complicated balance, between considerations of military necessity and humanity, by comprising those rules of international law which establish minimum standards of humanity that must be respected in any situation of armed conflict. As was highlighted by the ECTY, International Tribunal on the Former Yugoslavia, in its 1995 decision on jurisdiction of the Tadic case, an armed conflict exists whenever there is a resort to armed forces between states or protracted armed violence between governmental authorities and organized armed groups, or between such groups within a state. In IHL, as is remarked by Sassoli, there exists, however, no single definition of armed conflicts. Rather, there are two categories of them: international armed conflicts and non-international armed conflicts. Now, regarding the former, they are defined as opposing to a more state international armed conflicts, to opposing two or more states, either directly or indirectly, in cases in which one state exercises an overall control over an armed group fighting against the government of another state. This the first shot is fired, the first act of violence is committed, no need for intensity and no need for response from the affected state. On the other hand, non-international armed conflicts are those between governmental forces and non-governmental armed groups, or between such groups only. IHL of non-international armed conflicts are commonly known, only applies once certain levels of intensity is achieved by the parties in conflict against between non-state armed groups that are sufficiently organized. So two essential elements to know when we have an IAC. You have to fulfill intensity of the violence and you have to fulfill the organization of the parties. As was highlighted before, the two basic goals of IHL application in the context of armed conflicts are to ensure the protection of the civilian population and civilian objects from the effect of the hostilities, and to impose constraints on certain methods and means of warfare. While rules on the conduct of hostilities are formulated mainly as prohibitions in Protocol 1 and in the ICRC customary international humanitarian law rules, they are, however, easier to understand, says Sassoli, as prohibitions, but rather as not as prohibitions, but rather as instructions on how attacks must be conducted. These goals are materialized in general principles, which, as Pictet remarked, inspire the entire substance of IHL. Principles such as humanity, necessity, distinction, proportionality, and precaution. Now, the most basic of the principles in IHL is the principle of humanity, also called the Martens Clause, introduced in 1899 prescribes that in cases not covered by treaties, civilians and combatants remain under the protection and authority of the principles of international law derived from established custom, from the principles of humanity, and from the dictates of public conscience. It has been considered by some authors as an opening to natural law, which inspired the first IHL configurations. The principle of distinction under which the parties are to the conflict must at all times distinguish between civilians and combatants, if we're talking about international conflicts, or fighter, if we're talking about non-international conflicts. I will not get into the details of why in non-international conflicts we don't talk about combatants privilege, etc., but we talk about make a difference between combatants and fighters, and between civilian objects and military objectives. Attacks may only be directed against combatants, fighters, and military objectives, and not against civilians or civilians objects. Military objectives are limited to those objects which by nature, location, purpose, or use make an effective contribution to the military action, and whose partial or total destruction, capture, or neutralization in the circumstances related at the time offers a definite military advantage. Now, the principle of proportionality prohibits attacks which may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which will be excessive, that's the key element there, in relation to the concrete and direct military advantage anticipated. And the precautionary principle, under this principle, all feasible precautions must be taken in the conduct of military operations to avoid and in any event to minimize incidental loss of civilian life, injury to civilian, and damage to civilian objects. And it might be divided in three moments: precautionary measures before the attack, during the attack, and precautions against the effects of the attack. Now, in conclusion, what is clear is that IHL defines a set of objective normative standards that allows investment arbitrations to apply, without running the risk of entering the quicksand of addressing subjective political issues. Now, moving to the second part of my presentation, the relationship between full protection, security, and IHL, as Tobias Ackerman highlights in the introduction to his 2022 book, the sharp rise, and it was also highlighted by Judy very well, the sharp rise in arbitration claims lodged in the context of the bill in the Arab world and the conflict between Russia and Ukraine are clear indicators for a growing trend of investment disputes in the context of armed conflict. Although investment arbitration cases dealing with issues of armed conflict are novel, relatively novel, as Julie already said, this exists since the late 19th century, beginnings of the 20th century. Issues dealing with the interpretation between these two special regimes of international law are not novel. Take, for example, as Julie has mentioned, the 1990 AAPL Sri Lanka case, where responsibility of the state was claimed as a consequence of the destruction of a shrimp farm and the killing of its employees under a counter-insurgency operations performed by the host state. The problem is not that investment and IHL issues are raised, but the fact that arbitrators are not addressing them by resourcing to IHL. A possible cause for it was underlined by Sornaraya. He said, arbitral tribunals are not designed to deal with political issues, such as the characterization of the war, the legality of the use of the force used to suppress it, and other like matters that may concern the internal sovereignty of a state. As was presented in the first part of my presentation, issues like the classification of armed conflicts or the legality in the conduction of hostilities are far from being political issues. They are legal issues that could be resolved by the use of objective normative standards under IHL. I will now move to analyze full protection and security in investment law to propose that IHL sources may serve investment arbitration as guidelines to understand host states' due diligence obligations. As is critically analyzed by Patrick Dunbury in the Sendis Bolivia case of 2018, under full protection and security clauses, host states are subject to a twofold obligation. a negative obligation to refrain from directly harming the investment by acts of violence attributable to the state, duty to abstain, and a positive obligation to prevent the third parties cause physical damage to such investment, a duty to protect. Although initially, for me, as an international and human rights, international and humanitarian law lawyer, these distinctions between FPS negative obligation, called also a human rights obligation to respect, and a positive obligation to guarantee or protect makes sense. I am aware of the discussion it creates in investment law, where both scholars and arbitral tribunals challenge the idea of a dual obligation under FPS and rather consider full protection and security claims to be centered in protection against private violence or actions committed by third parties and not by state organs, where the focus is put in other standards of investment protection, such as for unequitable treatment. Sebastián Mantilla, very well-known scholar expert on the subject, who wrote a great book on full protection and security, does a magnificent job explaining the discussions since El Paso v. Argentina, influencing other awards like Electra Bell v. Hungary, Mobile v. Argentina, or Mercer v. Canada. Recent cases like Goodies v. Libya, 2021, do not contribute to clarify the issue, as it noted that under FPS, the state was not responsible for all damages caused by its organs, but was only required to exercise due diligence in protecting investment from them. Due diligence derived from negative obligations is something, at least for me, that it's not quite understandable. But the truth is that there are arbitral tribunals that will continue to address FPS claims by analyzing the obligation of host states to abstain when it comes to military operations in context of armed conflict, or as Schroer has said, to exercise restraint in the use of armed forces where a protected investor is involved. As we have seen, to understand if the conduct of the host state was wrongful and violates international law in this particular context is not a task for investment law exclusively, but in the scenarios of military operation and armed conflict, as it has happened in other branches of international law like human rights or international criminal law, the analysis must be done through the lenses of IHL. Ackerman explains it better. These arbitrators does need on a subordinary level conduct and assessment under humanitarian law. They need to examine whether the attack in question was directed at the investment, and if so, whether it conducted a lawful military objective. In case the investment was civilian and damaged incidentally, on the other hand, a review of the attack needs to consider the principles of proportionality and precaution. Tribunals thus also need to assess whether the state has taken all feasible means of precaution to avoid or minimize the harm. Am I too over my time or too over my time? So 1 minute left. So just let me, if we move very, very rapidly through the heart of the FPS standard, as is called by Mantilla, the protection against private violence, there is a duty to protect, where hosts must take measures to guarantee the security of investors against threats originating from private individuals, armed groups, foreign states, or any other third party. This cannot be construed, as was held by the ICJ in the Electronica Secula case, as the giving of a warranty that property should never, in any circumstances, be occupied or disturbed. The duty imposed upon the host state by FPS standard is not one of strict liability. Rather, the state is obliged to exert due diligence in order to protect a claimant's investment, a standard that must be assessed according to the particular circumstances in which the damage occurs, and was considered in Ample American Israel Court v. Egypt in 2017. Due diligence under FPS then is not an objective standard, but rather a modified objective standard where host state circumstances are relevant and a context-sensitive approach is needed. The idea of foreign full protection and security level of due diligence as a modified objective standard is credited to Newcomb and Parallel, and its implementation in investment arbitration was done by sole arbitrator Jan Paulson in the Panteniki v. Albania case. Now, in my opinion, and to close my presentation because I know that my time is lapsed, IHL standards will result to be useful for investors to understand, also as arbitrator, to understand the risk its investment will have in the context of an armed conflict. It will be essential for arbitrators to understand how reasonable and feasible a particular protective measure in favor of the investor was, for example, in scenarios where the principle of precaution obliged the military forces of the host state to override its military interests. The omission should not be construed as a FPS violation. Another example could be military operations that have a high level of military necessity, but incidentally affect the property of the investor. Responsibility under the host state due diligence should be different if those actions respected all the principles of IHL and its standards, that if they are not. Finally, as Ackerman highlights, the defender's duty of constant care under international humanitarian law should likewise inform the host state's due diligence to protect foreign investment if it takes the role of a defender in an armed conflict. In summary, in context of armed conflict, principles of IHL and investment coexist, are applicable, and must be harmonized. IHL-related questions are not political or state sovereignty invasive, but rather legal questions with clear normative objective standards and concepts to be used. I know that for this approach to be realistic, we must have hybrid arbitrators or tribunals, like Spain, with knowledge of investment and IHL. But certainly in this panel as well, we have clear examples of people who have that competence, not my case, but many of my panel have that hybrid conditions of knowing investment law as well as IHL. But if this results to still be too unrealistic, an alternative proposal could be an arbitrator's mechanism to call for expert witness when needed, to explain the context of a country, but to explain the particular issues regarding IHL, either by means of questions raised to the parties that will demand those reports to be submitted, or by having an ex officio faculty for arbitrators to request them, which I know that is highly controversial. I'll do my presentation. Thank you for your patience and your time, and I hope that I answered your questions, your initial question.
Thank you, Carlos. You certainly did. So I would like to highlight something from your presentation, and it's that when you excuse yourself to be into basics for public international law lawyers, I think that that was actually the objective of this, like understanding the basics in order to find a point where both regimes can coincide rather than collide. So thank you so much. Now we're moving forward to Santiago Zuleta. Santiago, welcome. The idea is that Santiago touch upon some very relevant topics nowadays on investment arbitration, and is the obligation or good practices, as you would like to identify them, of foreign investors on running due diligence and corporate social responsibility standards. So Santiago, you have the floor.
Thank you, Maria Lucia. Greetings, everybody. First of all, I want to thank Jose Antonio and World Arbitration Update for this invitation. I'm just going to be very quick, and I'm going to build upon the idea that Yuri just mentioned, and it's the obligation or responsibilities that investors have to carry on due diligence, specifically human rights due diligence in context of armed conflicts. And specifically, I'm going to focus on two things: the sources of this obligation and the content of these obligations. So for the clarity of this presentation, I'm going to divide what I'm going to say in three parts. First, I'm going to talk about the general obligations that investors have to carry a due diligence. Then I'm going to move to a second level of interpretation, and it's the new standard of the human rights due diligence. And last, I will mention very briefly the obligation or the standard of carrier due diligence in particular context of armed conflicts. So to begin with, I would like to mention that there's no discussion nowadays about the obligation that investors have to carry on a due diligence. The principal sources of these obligations are the general principles of law, particularly the general principle of law of good faith, in which it is understood that the investor or a person has a standard of care that is to be reasonably expected or that is legally required to comply with. And it's important also to highlight that this is an obligation of conduct, not of result, as has been mentioned in the famous Corfu Chanel award. The second source of international law where you can find this obligation are, of course, bilateral treaties, and particularly in the context of fair and equitable treatment and legitimate expectations. So these two sources of law put in the head or in charge of the corporation or the person that is doing the investment in this case to carry on with this particular kind of obligation. And I would like to add that to comply with this obligation, in order to comply with this obligation, what is expected from the person that has the duty to comply with it, it has to carry on an assessment on the legal risk or the legal framework of the country where the investment is taking place, but also the political and economic context. So in a second level, or moving forward, it has been proved that this is not enough, this due diligence is not enough to prevent corporations, in this case, or investors, to harm human rights. So after an intense debate, the figure of a human rights due diligence was included on the UN guiding principles on business and human rights, more known as the Ruggie principles. The Ruggie principles on principle 17 particularly order or ask the investor or the corporation who is doing the investment to prevent, mitigate, and publish what he is doing or the conducts that they are taking in order to prevent harming human rights. This is related to another principle of international law that it's very common and known to all of us, which is do no harm. You can, or there's also another mention to this particular principle or this particular obligation in the draft treaty on business and human rights that is being negotiated now in Geneva. Right now, it's in the 4th round, and particularly Article 6.3 assets that to identify, assess, and publish any actual potential human rights abuses that may arise from their business activities or relationships. That's the principal standard that is contained in these two sources of international law. Of course, there's a debate because the first one is soft law. The second is a treaty that has not been ratified. But as you also probably know, there's different mechanisms in which soft law can be hardened, particularly, or for example, one way is the national regulation that it's taking place nowadays in Europe. There's a bunch of examples, or some examples are the duty of vigilance law in France, and also the recently law passed in Germany. And though the second sources of this obligation, which is the draft treaty, has not been ratified, in the future, there is a great probability that's going to become into force, and that states that ratify this draft or this treaty will have to comply with this obligation. And regarding the content of the obligation or the conduct that the duty bearers of these obligations have to follow to comply with it, The most important ones is to identify the human rights that have the potential of being harmed. And to give you just some examples, I'm thinking about land rights or property rights, also all the human rights related with indigenous communities and their territories. It has been highlighted in the Inter-American Court of Human Rights in recent awards. Also, all the rights related to work and labor rights. And finally, and this will take us to the last and third level of this analysis. It's armed conflicts, or the rights and principles that can be harmed during an armed conflict, particularly the principles of international humanitarian law. Just to give you two examples of awards where the tribunal has analyzed this duty of investors to do the due diligence. I encourage you to check the South American silver against Bolivia and Bear Creek against Peru. And the last level of this obligation has to do with carrying human rights due diligence in context of armed conflict. Again, the UN guided principles of human rights on principle 7 and 11 encourage investors to take further steps or additional steps in order to comply with this obligation. And also there's a reference in the draft treaty on business and human rights, specifically on articles 6.4G. One of the most difficult or the big challenges that investors have when defining or understanding when an armed conflict is going on, it is by looking at the definition on what is a non-armed conflict. There's one reference, as Dr. Carlos just mentioned, the definition is contained in the Geneva Convention and additional protocols, even though there's some discussions, but investors should look at that definition. And if the situation in the country matches with what the definitions in these instruments have, well, then it should do and start the process of making due diligence. But there are some situations where states deny the existence of these armed conflicts. For example, Colombia is one example whereas a public policy, the state denies the existence of an armed conflict and reframe it or by the name of a terrorist threat or social unrest. So in these situations, it can be or there's a scenario where the investor can have some confusion between what is defined under international law and what is defined by the state receptor of the investment. And to finish with this third part of the analysis of this obligation, the particular conducts that are expected for the investor to take or to look at after making through all the process of the investment are first, which are the regions where the investment is going to take place. For example, in the case of Colombia, it's not the same to make an investment in Barranquilla or in Bogota, where you have strong rule of law or where you have institution, than doing the investment in other territories that have been torn apart by war or by conflict, like, for example, Guajira, Caquetá, or Catatumbo in this case. A second aspect that investors should look up is state control of the territory, because that's also another element that is going to be taken into account when the investor allege the protection from international investment treaty. Third, the armed groups. It's important to characterize the armed groups that are present in the territory and understand the logics and the tensions and the risk that involves having a particular operation in these places where there's different groups involved in the daily operations of the corporation or the investment. And the fourth element that is very important, and it's also the case of Colombia, but it's also an example that you can find in other countries, for example, Peru, Honduras, and it's going to be, I think, a hot topic or a big part of the discussion in Ukraine after the war is ended, if the transitional justice process that most of these countries are engaging to move from one stage of the war to a peace full time. So this could have a big impact on the expectations of the investor, and also it can change the framework from the moment that the investment was made, from the moment of the claim. To finish my intervention with a conclusion is that investor negligence can lead to a lot of protection under investment treaties. And to what extent can an investor claim that his legitimate expectations were violated when due diligence was not performed? That's the effects of not doing the due diligence. That can be one of the legal effects. And the next questions that coming to my mind, that part of the discussion that the investor have to look up are how do I do the due diligence? What is the information that I need in order to prove to the tribunal that I comply with the standard that was required by international law? So with that in mind, I would like to thank you again for the organizations, to all my colleagues for sharing this floor with me, and I'll go back to you, Maria Lucia. Thank you.
Thanks, Santiago. I think this is one of my favorite topics, actually. And if we really want to find a balance in the system, we really need to take into account this and to learn about this. So thank you for your presentation. Due to sake of time, I will move now to Amanda Lee. Amanda will provide us a more practical perspective of what could happen if the application of norms of both regimes apply or collide. So Amanda, you have the floor.
Thank you very much, and thank you to World Arbitration Update for the kind invitation. I'm someone who likes to identify problems, so I'm going to use my time to speak briefly about two key areas of potential conflict between international humanitarian law and investment law, namely the challenges presented by the important principle of re judicata and the overlapping jurisdictions of adjudicative bodies that are sometimes tasked with addressing matters falling within these two legal fields. Now, as we all know, the doctrine of re judicata provides that a final decision by a court or tribunal will be conclusive in subsequent proceedings involving three things: the same subject matter or relief, the same legal grounds, and the same parties. And a recent example helps to illustrate some of the difficulties that may arise. In February 2023, the International Court of Justice issued preliminary measures in proceedings between Armenia and Azerbaijan, in which the parties were accusing each other of violating the International Convention on the Elimination of All Forms of Racial Discrimination. The ICJ ordered Azerbaijan to, and I quote, ensure unimpeded movement of persons, vehicles, and cargo along the Lachin corridor, I apologize to anyone if I've mispronounced that, the only land route by which its neighbor Armenia may access the disputed region of Nagorno-Karabakh. Now, although this region's part of Azerbaijan, the 120,000 residents are in the main ethnic Armenians, and Armenia's position was that Azerbaijan had implemented a blockade as a means of, and again, I quote, ethnic cleansing, which is a claim denied by Azerbaijan. So the case continues. In the meantime, though, less than a week after the ICJ's order was made, Azerbaijan initiated the first known interstate arbitral proceedings under the Energy Charter Treaty against Armenia. Now, although the basis for the claims is different, we're looking at different treaties, it's difficult to escape the conclusion that this was by some means a retaliatory step in what is substantively the same dispute seen through a different lens. And the claim arises from what Armenia describes as the nearly 30-year illegal occupation of its territories, and a dispute that, as with the ICJ claim, stems from the Nagorno-Karabakh conflict. So we therefore now have two different forums exercising jurisdiction over disputes that arise from the same conflict and have certain features in common. And this overlap has the potential to give rise to adjudicative inconsistencies, not least because ICDS tribunals often don't apply the principle of re judicata consistently. And that's a particular note in the context of armed conflict-related disputes, where the doctrine of jurisprudence constant is particularly important. So why do we have a problem here? Well, divergent application of the doctrine by tribunals is unhelpful when it's the application of res judicata that will determine whether specific claims will be adjudicated on the merits. So the southern bluefin tuna case is illustrative of the practical implications. In that case, the tribunal concluded that the dispute that had arisen between the parties was not, in fact, two separate disputes arising under UNCLOS and the 1993 Convention for the Conservation of Southern Bluefin Tuna. That convention just doesn't get talked about enough, I think, respectively. But in fact, one dispute arising under both conventions. And it was therefore held that it would be artificial to distinguish them. And that's all well and good, but unfortunately the self-regulated nature of ISDS makes it more prone to inconsistent applications of the res judicata doctrine and the application of independently construed criteria. And the unavoidable result is the potential for matters to be relitigated, a struggle to achieve jurisprudence constant, and particular difficulties when the fora dealing with the matters to be adjudicated are different, as in the Azerbaijan and Armenia example. As a generality, the application of the res judicata doctrine is inconsistent in ISDS jurisprudence. The wide scope of subject matter jurisdiction under investment treaties, including the ECT, makes ISDS the ideal forum for states that have been the subject of an adverse decision before an alternative adjudicative forum to try their luck and seek to obtain a different decision before an ISDS tribunal. Basically, it's a form of forum shopping. Plus, the relevance of ISDS awards has significantly increased over the years, with an ever-growing number of cases raising its international profile and its use to resolve disputes increasing. So we have a growing body of ISDS jurisprudence, which makes it more likely we're going to spot some of these inconsistencies. So how do ISDS tribunals apply res judicata principles? Well, the answer is that it depends, which frankly is itself a problem. So, for example, in Helnan International Hotels in the Arab Republic of Egypt, the tribunal took a strict approach, concluding that an award previously rendered in Cairo didn't have res judicata effect in an ICSID claim because the two operated under different legal regimes and the relief sought was not fully identical. The tribunal in CME adopted a similarly narrow approach, concluding that a claim may only be dismissed on the basis of res judicata if the claims were in all respects exactly the same, and I quote. And on this basis, a matter would be dismissed only if both claims were completely identical. So two identical claims brought under the auspices of two different treaties could be addressed by two different tribunals, potentially with two different results. Res judicata would not apply despite the identical subject matter and parties due to the different bases of jurisdiction, two different treaties. And basically the result was therefore that parties could arguably have two bites of the cherry. Now, some ISDS tribunals have adopted a more flexible approach to res judicata, including Waste Management, Inc. and United Mexican States. Tribunal in that case held that the triple identity test was satisfied if two matters concerned the same question. It's regrettable that there is no real clear public international law guidance on the attribution of primacy to one forum, such as the International Court of Justice, over another, such as a tribunal appointed pursuant to an ISDS provision in a BIT, in respect of disputes arising from armed conflicts in particular. What we find is that disputes arising from armed conflicts may therefore fall within the jurisdiction of multiple adjudicative fora, both judicial and potentially non-judicial in nature. And there are numerous examples of ISDS tribunals wrestling with specific IHL norms and coming up short, with a prime example being AAPL in Sri Lanka, which is an ICSID case in which a tribunal found that Sri Lanka was in breach of its obligation of due diligence. In that case, AAPL's shrimp farm was destroyed by Sri Lankan military forces. The tribunal ordered Sri Lanka to compensate AAPL for its lost investment. And Sri Lanka had sought to argue that the shrimp farm was in fact being used by rebel forces as a, and again I quote, terrorist facility, but such argument received short shrift from the tribunal. Now, critics may argue that the tribunal there failed to thoroughly assess the due diligence principle against the backdrop of the then prevailing armed conflict. And likewise, in Copper Mesa in the Republic of Ecuador, the tribunal held the state liable for its failure to control a civil uprising. This wide interpretation of the full protection and security standards failed to engage fully with public international law norms such as state responsibility in order to determine whether the uprising was attributable to the state. And in Pantechniki and Albania, the tribunal attributed greater importance to the same standards and failed to engage with IHL norms. So we have ISDS bodies that fail to properly engage with IHL norms, potentially re-adjudicating claims that arguably should not be relitigated due to the res judicata doctrine. doctrine. And frankly, that's a recipe for disaster, particularly if we're to expect disputes arising from armed conflicts to be addressed fairly. So lots of problems there for you. Sadly, I don't have solutions, but I'm sure that somebody far cleverer than me will have.
Thank you, Amanda. Now to finalize, we are moving to Eduardo. Eduardo will discuss or will enlighten us, or maybe we'll leave some questions open, as Amanda did, about certain substantive provisions that may remain applicable or not during time of armed conflict. Eduardo, you have the floor.
Thank you, Maria Lucia. Thank you very much. It's a pleasure to be here, and thank you for the invitation. It's a pleasure to join such a group of distinguished colleagues. I'm going to focus on whether or not the provisions of investment treaties would apply in case of armed conflict. But I'm going to focus on a very specific and different issue here, which is the internal armed conflict. We have heard from Amanda, from Yure, from Carlos, the standards and the effects of an international war, an international armed conflict. But what I want to focus on is on what are the consequences of an armed conflict when there is an internal armed conflict. And the first question here is a legal and a political question that is very much applicable to the case of Colombia. What is the standard and what is the definition of an armed conflict? Of course, we can resort to the treaties, we can resort to the international doctrine, we can resort to the international jurisprudence. But then we have a political element in the case of Colombia. You all know that for years, several governments denied the existence of an armed conflict and assumed the position that what was happening in Colombia was a terrorist attack against the legitimate institutions, and I put that into the quotation marks. Now, the present government, as we heard from Dr. Zamora, and as we've heard from the government, has taken a totally different approach. And the approach is that the government has acknowledged the existence of an armed conflict, has acknowledged the existence of an internal armed conflict, and an internal armed conflict with some influence from external actors. And when I say external actors, I mean actors outside of Colombia that operate within Colombian territory. And that has a very important and specific consequence in the case of Colombia, because a state cannot, on the one hand, claim that there is no armed conflict, and on the other hand, attempt to defend itself in investment claims by alleging the non-application of standards of treaty protection that are not applicable in the case of armed conflict. And what are those standards that would not apply or that we have to consider in the case of armed conflict? First, and I'm saying nothing new here because it has already been mentioned, the articles of the International Law Commission, the draft articles on the effects of armed conflict, contain a sort of a presumption. The existence of continuity, the existence of an armed conflict does not per se terminate or suspend the operation of the treaties. Second, the Vienna Convention on the Law of the Treaties, as you know, contains provision on the supervening impossibility of performance and fundamental change of circumstances that may be invoked in case of conflict. Third, many bilateral investment treaties, and that was mentioned by Dr. Zamora, contain clauses referring to losses or compensation owed to war or other forms of armed conflict or like events. These clauses provide for restitution or compensation in the case of armed conflict, but there are clauses there in investment treaties that do not necessarily create an absolute right to compensation or to restitution, but are limited to a promise of non-discrimination in case there's a program to indemnify the victims of the armed conflict. Of course, the other provisions that one has to consider in case of an armed conflict and whether they apply or not and how they apply are the fair and equitable treatment, whether clauses of fair and equitable treatment can still be said to apply, particularly in fair and equitable treatment, as Santiago was mentioning, whether and to what extent legitimate expectations may apply in a case of an armed conflict, particularly when the investor has not performed a due diligence or has performed an insufficient or incomplete due diligence. And the due diligence in the case of an armed conflict, as in the case of Colombia, where you have not one, but several groups, as Carlos mentioned already, interacting within the territory requires a great degree of investigation and knowledge of how these groups operate, at least in the areas where the investor is going to interact. The other sort of clauses that you may find in investment treaties are the so-called extended war clauses, which include a compensation for losses caused by the type of conflicts that we are talking about. One example of that is the Energy Charter Treaty that contains in its Article 13, if I'm not mistaken, one of the so-called extended war clauses. And then, of course, you have the clause of the full protection and security. As you all know, there's been a huge debate on the full protection and security clauses. On the one hand, as to whether full protection and security applies not only to physical harm, but also to legal changes. The trend in the tribunals lately has been to restrict the application of the full protection and security standards to situations of physical harm as opposed to changes in the legal framework. But the key thing here, and Carlos already mentioned that, is one, whether it goes to full protection and security clause goes to both the duty to protect and the duty to refrain, a passive and an active action, and whether in case of armed conflict, the provision applies. But more than whether or not the provision applies, which is in itself a debate, the other question is, what is the standard? Is the standard to be measured against the conduct of a very well-organized modern state? Or should it be a subjective standard? To put it bluntly, can the standard of full protection and security in the case of Colombia be measured with the same standard of reasonable use of the state capabilities that would apply to a state of Western Europe or to the United States? Or should it be considered in the subjective and particularities of the case of Colombia? And finally, as I was mentioning, the other two clauses or the other two provisions that are at the core of the investment disputes when there is a situation of armed conflict are the ones that you will know because of their application in the vast majority of the Argentinian cases, the clauses of necessity on the one hand and force majeure on the other, that again are tied to the key issue of the obligation of the investor to perform due diligence. So in a nutshell, and in the particular case of Colombia, there are three things that I should mention to conclude this brief presentation. Number one, there is a key obligation of investors to perform an adequate due diligence in the issue of arms. Number two, the position that the present government has taken may be more favorable in the sense that to the extent that it is recognizing the existence of an armed conflict, then the standard to be applied may be more lenient than the position that the government took in the past, of simply saying there's no armed conflict here whatsoever. All we have is a terrorist attack, because in that particular case, of course, the duty of the government, without recognizing the existence of an armed conflict, would be to protect the investor against terrorist attacks, period. And last but not least, in the present situation of Colombia, there has to be a very careful review of how the standards of protection of investors apply. Colombia cannot simply say, well, we have treaties that protect the investors. Yes, but the treaties protect investors under special circumstances of internal armed conflict that the government has recognized. And the treaties should be applied and should be interpreted considering that particular situation, and considering, again, how in that particular scenario, the provisions of the treaty would apply, would not apply, or would apply with a lower standard in the case of claims against Colombia. So thank you, Maria Lucia, again, and thank you all for having stayed in this very interesting panel.
Thank you, Eduardo. We still have some minutes left. So before we give 1 minute to each panelist to give some closing remarks, I would like to pose a question that was sent through the chat by one of our participants. So it says, shouldn't Ukrainians have priority over third-party foreign investors in receiving compensation in ISDS, since Ukraine and its nationals have suffered enormous losses and the amount available for compensation will be limited? And also I would like to ask, what will prevent ISDS tribunals from handing down awards and those receiving them from seeking to obtain assets through enforcement under the New York Convention or the Washington Convention, depleting resources available to Ukraine? I don't know which of the panelists would like to answer that. Perhaps Eduardo, since he's the expert on investment arbitration, but I'll leave it to you.
Unfortunately, I can't, because I do have a conflict on that issue as an arbitrator, and I cannot opine on that. That's the reason why I refer mostly to Colombia, and I refrain from commenting on Ukraine cases. Sorry, but it is what it is.
Completely understand. Any other of our panelists would like to
probably address the first part from the Colombian experience, and is just the first part, not the one related to investment, the rules, investment, preparation of their investment. But when you have a conflict, complex conflicts such as the Ukrainian one or the Syria one, Libya, or the one in Colombia, whenever you're trying to get, to promote a way to get out of this conflict, and you have a great number of victims, which is what happened here in Colombia, more than 8 million. You have to realize that regular, ordinary means for operations are not going to be successful. So my answer in the case of Ukraine is going to be for the people of Ukraine, and we all hope that the conflict ends soon, and that we have an opportunity to see through means of transitional justice that will lead to a full reparation of the victims, to understand that full reparation is going to be a reparation in different ways that are not going to be the traditional ways of economic reparation that will cover all the costs of the damage that have been caused because of the massive amount of injuries and harms that have been created. That has been the experience here in Colombia. the Inter-American Court of Human Rights has addressed the issue and has even recognized that those means, for example, administrative reparation that is not full reparations, are valid in a scenario of massive human rights violations, such as the one that we have suffered. I don't know if it's helpful, but that could be a probable answer to I mean, from a more human rights, transitional justice perspective to the question.
Thank you, Carlos, for jumping into that. Any additional comments from our panelists?
I can just add to the question concerning whether Ukrainians should have priority over third states, foreign investors in receiving compensations in starting investment arbitrations. They have suffered more. That would be a logical conclusion. There is no order of priority. There is nothing I can think of that would enable that. And also whether there is anything that would prevent ISDS tribunals from handing down awards which would ultimately deplete Ukrainian resources. Again, unfortunately, nothing. So as we have seen from the experience of Libya, a great number of investors have brought investment claims against a country that was completely shattered by the conflict at the time when the country was still immersed in conflict, and handed down arbitral awards. One of them, Al-Kharafi, notoriously very high. At the time, it was, I think, the highest arbitral award in the history, 1 billion, which amounted to more than 1% of the Libya's budget. And in addition to many other arbitral awards that amounted to millions of dollars. And of course, this raises concerns about fairness, about how these compensation awards can divert resources from a country that are needed for rebuilding infrastructure, that are needed for fighting off the rebel groups that are trying to overthrow democratically elected government, that can complicate the transition from conflict to peace. And these are all serious, legitimate concerns. What are the solutions? One of them could be that the home states of investors are waiving procedural rights under investment treaties for the investors. Is that feasible at all? Depending on how we conceptualize procedural rights of investors. If we conceptualize them as investors' direct rights, that's not possible. If we conceptualize them as effectively the rights of the home states, that would be possible. But the prevailing position in investment law is that procedural rights to start arbitrations belong to investors, not their home states. Another potential solution would be to replace investment arbitration with a post-conflict hybrid tribunal or mixed claims commission, something that Carlos has mentioned was very popular in the past, something tantamount to Iran-US Claims Tribunal, something tantamount to Eritrea-Ethiopia Claims Commission, that will have jurisdiction over all the claims stemming from the war in Ukraine. And that could solve a lot of issues that have been raised today by Amanda as well, the risk of inconsistent jurisprudence, the risk of investors getting unjustly enriched, the risk of states being bombarded with claims and having to fund multiple litigations and arbitrations, as well as the risk of exorbitant amount of compensation affecting the economy of the state, whose financial capacity to pay has been heavily impacted, and the potential impact of such compensation awards on the livelihood of the people, as well as on transition to peace. Whether that will actually happen or not, we'll have to wait and see. But I think that in such situations of intense conflict that result in large number of claims, large-scale liability matters, one single post-conflict tribunal with a jurisdiction to adjudicate all the claims would be a much more appropriate solution than a heavily fragmented ISDS system.
Thank you. I would like to ask a last question, and it's what new, and it goes to all the panelists. So what new or additional provisions in an exercise, of course, of creativity, and taking into account the circumstances in various countries in armed conflicts, will you include in new investment treaty models? Which kind of provisions?
Cool.
And it's a hard one.
Because new models, this is something that was discussed a long time ago. New models now include human rights, environmental development issues. I know that Madam Director of the agency highlighted the idea of including inside investment treaties some regards to the internal situations of the country and probably the conflicts of, etc. But I think that's problematic regarding investment, and also something that both Eduardo and Santiago highlighted, and it's the fact that there can be a change in the situation regarding those, conflicts. To give you an example, in Colombia, in 2020, there was a public classification done by the ICRC of the conflict, and we had 5 conflicts. Then we turned to 6 conflicts, and now we have 7 conflicts. And there's a discussion that is there even an 8th conflict? Of course, none of them is an international conflict. So there changes and develops all the time. So no, I wouldn't, if the question goes through that proposal of having more specific country-related clauses regarding armed conflict, I would say no. But then I don't think of additional ones that could be created. Maybe the ones that are already created can be more clear, but then I'm not an expert on this, so I wouldn't directly to say that.
Thank you, Yuri. Would you like to jump to some remarks on that?
Yes, I'm not sure if I understood the question correctly. I think it concerned potential reforms of investment treaties when it comes to interaction between investment law and armed conflict. I will step into the territory of Santiago, because I think that the topic of obligation responsibility of investors is very important, often neglected when it comes to regulation. And I think a better link between investment law and investor obligations and other regimes that provide for obligations of investors in times of armed conflict should be established, either soft law regimes like the UNGP and other soft law initiatives, or more hardcore obligations of the international humanitarian law, as for example, obligation to refrain from committing war crimes, which is binding on investors, not only states and armed groups. So such provisions that would open up avenues to enforce such obligations against investors would be welcome. I have found a clause in the Colombia model BAT, which also minimizes the interaction between investment law and a transition to peace. And I thought it was quite a good clause and commendable. And if I read it, it says that basically, it says that government measures in compliance with the peace agreements between the government and armed groups does not constitute a breach of the investment treaty, and investors must participate in successful implementations of the peace agreements and the achievement of full reparation to victims affected by the Colombia armed conflict. Now, this was just an addendum to 2017 Colombia BAT, but following this addendum, this would suggest that Colombian land restitution program involving the forfeiture of investors' land rights over a property that was previously taken from the victims of armed conflict could not give rise to successful investment treaty claims, which could potentially complicate the transition to peace. I think that's an example of good drafting.
Thank you, Jure. I'll now yield the floor to Jose Antonio, which is finally here. So Jose Antonio, you have the floor.
Thank you, Maria Lucia. And just very briefly, I would like to thank each one of you for being here. And again, sorry. Thank you, Maria Lucia. And I would like to thank each one of you, the panelists, Eduardo Zuleta, Santiago Zuleta, Amanda Lee, Yuri Strilik, Marta Lucia Zamora, and Carlos Enrique as well, Carlos Enrique Arevalo. This has been a fabulous panel. Unfortunately, I was in the midst of weather conditions and flight overflights, overbooking, etc. So I apologize for that, but I was able to listen to most of the panel or parts of it. I certainly missed a lot, but one, this is a good example that the World Arbitration Update is not one or two people, it's a whole team, and Maria Lucia has done an incredible job. So I would like to thank her for moderating this panel. This is beyond the strategy team and the World Arbitration Update team. It's a world effort because there are panelists, there are moderators here and there. So I would like to thank everyone. Beyond that, this panel is I believe, an incredible example. We had more than 80 people connected. We had more than 30 people in person, or 20 people in person. And this is an example of what we're trying to achieve in terms of the World Arbitration Update. We're really trying to decentralize international arbitration and looking into the circumstances that may be also not in the main centers of the world, in the developed economies, but in economies that are there and are having special circumstances. And one of the special circumstances is, of course, those that are going through armed conflicts, either war or internal armed conflicts. And the last question that was asked in terms of what BIT model clauses could be thought of to incorporate international humanitarian law and the law of war into investment treaties is one that necessitates much thinking to integrate two parts of the law in international law that seem to be still far apart, with the exception of those like Dr. Strilik, who have already tried to integrate it in some way, and on others. So I would like to conclude by thanking each one of you and inviting the participants, the moderators, the panelists to bring to our attention topics that may be forgotten or not given sufficient attention, so that we can make them part of our schedule in 2024. As far as international humanitarian law goes and investment treaty arbitration, the idea is that this would be a first one. We already have thoughts about a second one connecting both topics, and certainly we will be reaching out to those who have expertise on the matter. So with thanks, we will be now moving into the code of conduct, which is now a reality. And thank you everyone for their attentive presence. Bye-bye.
Thank you all. Bye-bye.
Thank you very much. Bye, everyone.
Thank you. Bye.